So the court just decided this case called King versus Burwell, which may not be the final word on the legal issues, and certainly is not going to end the political debate about the Affordable Care Act. But for now, settles things for the foreseeable future. The bullet dodged here was that were the tax credits denied to individuals who signed up on the federal exchanges, which again, it's 36 states, those exchanges collapse, because you no longer have people who can afford the health insurance, and the whole thing is defeated. The Affordable Care Act, or the Obamacare, it's a huge, messy, omnibus nightmare of a statute, but it does three core things that are quite simple. Step one, insurance companies have to cover pre-existing conditions. Step two, everyone has to buy insurance. So step three is significant financial support for poor people to help pay for their insurance. Medicaid is a version of that. But what about people who aren't poor enough to be eligible for Medicaid, but still aren't rich enough to really pay for a policy? Folks just above the poverty line. And so the third big initiative of the law is to provide subsidies for those people to pay for the insurance that the individual mandate requires, so as to support the economic viability of the ban on denying people for pre-existing conditions. So the subsidies are in the form not of direct payments to individuals, which they can then in turn use to pay for insurance. They're in the form of tax credits. The statute says they're available to everyone who qualifies economically, but for insurance bought through an exchange created by a state. And that's the key language, these four little words, exchange, create, five little words, create, exchange created by a state. The statute literally says every state must create an exchange. And if a state elects not to create an exchange, the Department of Health and Human Services is required to create, quote, such exchange. And the plaintiffs in this case are four people who live in Virginia. Virginia has a federally established rather than a state established exchange. And they say, we are not eligible for the tax credits because those only can be provided to offset premiums obtained through an exchange established by a state. We don't want our tax credits. Don't give us our tax credits. And the issue is, can you read that phrase, established by a state, to include the state-level exchanges that are actually set up by the federal government? 6 justices, in an opinion by the Chief Justice, conclude that the phrase established by a state includes exchanges established by the federal government. The basic division is usually described as textualism on the one hand and purposivism on the other. In other words, do you just look at the words of the text and stop there? Or do you think more broadly about the purposes Congress was trying to achieve? Why did Congress write this statute in the first place? And should we read it just looking at the words or in light of those purposes? So in this case, what you have is Justice Scalia in dissent focusing on this phrase and just saying, look, it says established by a state. That means not established by the feds. That's the end of the case. What the Chief Justice is doing is thinking in terms of the overall structure of the statute and Congress's overall goals, and trying to read the statute and looking at this phrase contextually. And there are a whole bunch of clues buried in the different parts of the statute that suggest, in fact, Congress really didn't mean overall to distinguish between federal exchanges and state exchanges. It really meant for there to be exchanges. We didn't know who was going to set them up, but once they were set up, they would operate identically. And there are many provisions that suggest, in fact, folks who have signed up on a federal exchange will indeed get the tax credits. And the overall thrust of the Chief Justice's opinion is to say, let's try and make this statute work. Overall, Congress wanted the exchanges to function, not to fail. And we will read the statute in a way that helps them function rather than guaranteeing their failure.